We opened our doors for business in London over 40 years ago, and we're still trading on the same values now as we did then. Professional, dedicated and trusted. We are the MECO Group.
We've encountered a number of instances in recent months where a vessel's line has parted at a berth, typically in the eastern tropical areas of the Pacific, and this has led to a claim by the owner on the basis that the berth or the port is allegedly unsafe, and that is the reason for the lines parting. This normally arises where there are swell conditions at the berth. Swell is a kind of mechanical wave. They're caused by seasonal conditions, distant weather systems. So swell conditions affect whole areas of coastline, and so this is this gives rise to an allegations that the berth or the port is unsafe. Unsafe has a legal meaning under English law, which is set down in the case of the Eastern City. That a port or a berth will not be safe unless the particular ship can reach, use and depart from it without, in the absence of abnormal occurrence, encountering danger which cannot be avoided by good navigation and seamanship. So that's the definition, and so these disputes regarding vessels' lines breaking, they have both a legal side concerning that definition and a factual side concerning the circumstances in question. So a number of these disputes have cropped up. The factual sides of the dispute they'll concern whether the vessel's lines were seaworthy, whether they were well maintained, because if that's the true cause of the loss rather than the unsafety of the place, then there'll be a defence. The charterer's defence might also allege that there was negligence in relation to navigating the port and the berth, that they might argue that there was not a proper allocation of bow, spring and stern lines, or that they were not applied diligently. And that's the reason for one of the lines parting. So there's a factual side, facts which can form the basis for defence or which owners need to prove in order to substantiate their claim. But there's also a legal side, and this is quite interesting in that if the charterers have warranted the safety of the whole port in their charter, then they will be liable for risks affecting the port as a whole. And swell is typically something which affects an entire port. Because of its seasonal nature and the fact that it affects entire stretches of coastline. But interestingly, where the charterer has not warranted the safety of the port, therefore, the owner is on risk. The owner is on risk for swell, and the owner is absolutely liable to have their vessel call at the port. What makes the legal side of this more nuanced, and what we've encountered in a few cases of late, is where the port is named in the charter. And there is no warranty of safety regarding the port, but the charterer is required to nominate a safe berth within the port, and this therefore raises the question of how the allocation between the owner being on risk for the port but the charterer being on risk for the safety of the berth ought to be dealt with. There's English case law on this point. There's a 1987 case called the APJ Pretty, which it concerned a vessel which was hit by an Exocet missile on an approach channel to the berth, and there was a charter which had no safe port warranty, but it did have a safe berth warranty. At the time the vessel was hit by a missile, of course making the place unsafe, it was on a voyage which was common to many berths, but not unique to the particular nominated berth. And so what the judges found in that case is that where there's a safe berth warranty, but there's no safe port warranty, the unsafety of the berth, in order to be actionable, it needs to be not common to every berth in the port, or not common to the port as a whole. And so what we found in these cases is that typically the charterer will actually have a defence, even though they've nominated the safety, even though they warranted the safety of the berth, because we would expect the swell conditions to affect the entire port. So it would only be in circumstances where the nominated berth is uniquely exposed to swell, if it's particularly prominent perhaps, or if the draft of the berth is very shallow, that there might be a prima facie legal case.